Prior art. What we have seen so far is the fact that invention advances technology. An invention results in a progress of a technology. Technology advances by way of the invention. How do we know this? We know this when we compare the invention with what has gone before in the field of technology. Now, the knowledge that has gone before in the field of technology is referred to as prior art. Alternatively, it is also referred to as state of the art or background art. Now, you will find that the word prior art figures in the Patents Act. This is a copy of the Patents Act, and we are in section 2 where the definition of new invention is mentioned here. A new invention means an invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing the patent application with complete specification. That is, this is the critical part. The subject matter of the patent has not fallen in public domain, or that it does not form part of the state of the art. So you find mention of the term state of the art, which we have just mentioned is nothing but prior art, in the Patents Act. The Patents Act also mentions prior art in the context of multiple priorities. We will come to that later, but prior art or state of the art is what has gone in that particular field before the invention came into being. And in fact, the invention is constantly covered with the prior art. Now, if you look at a definition for prior art, and one definition that's available for us is the definition in the European Patent Office website. Now, it defines prior art as any evidence that your invention is already known. So by prior art, we are referring to some kind of evidence. Now, in law, an evidence can either broadly fall within the category of an oral evidence, which is what people say, and it could be documentary evidence, evidence that is documented. So prior art in patent law, predominantly we are talking about documentary evidence against your invention or something which shows that your invention is already known. Now, it does not need that the prior art should physically exist or it should be commercially available in the form of a sale. It is enough that somebody has described it or shown it or used the technology. Now, you could say there are many things that could amount to prior art. A cave painting can amount to a prior art. Instruction manual can amount to a prior art. A thesis lying in a library, an unpublished thesis, can amount to a prior art. In fact, anything that has the value of an evidence can amount to a prior art. We find that prior art, at least the documentary part, is something that you can search. And you can search for the prior art in various places. Now, any evidence, which means published, unpublished, currently used, discontinued, if it is in a searchable form, if it is documented and if it's in a searchable form, then that qualifies for prior art. Now, you will find that the internet is one of the best places where you can search for prior art. And which includes, if you are looking at patents, you can look at the Google Patents website, which is a repository of many of the patents that have been published. You could also look at patent office websites like the Indian Patent Office website. You have a search page which shows the Indian Patent Office patent application can be searched. The ESPACEnet patent search, which is the European Patent Office website search, or USPTO, which is the United States Patent and Trademark Office search. These are, and there are other national patent offices where you could search for patents. You could also do a non-patent literature search in Google Scholar or any other non-patent literature database. Now, the links are provided below. You can see that a Google Patents, this is how it looks, the web link, and you could search it's a common word search. You can search any of the terms that you want to look for and you can find it here. It just operates like the normal Google search. The intellectual property website of India looks like this. So you could add any of you can search by title, by abstract, by complete specification, and you can also search by date. You have an option of choosing published and granted patents. Now that is also there. So if you're looking at published pending applications, you could search that and you can find. Now the European Patent Office also has a search. Patent search is called ESPACEnet. You have more than 100 million patent documents here. So this provides you the search for that. The US Patent Office has its own search, and this is the database, the link from here. And the US Patent Office is also important because they also provide some search strategies. The 7 steps search strategy. It's an interesting piece of document. You should have a look at that in some detail. And for everything else, you have the Google Scholar and anything that falls within the public domain. Now, this summarizes the search before the various databases. You could generally do a patent or a non-patent literature search in any library where these documents are stored, or in any place where you can have access to the hard copies. Now, but knowing the way in which technology has progressed, most of the patents that have been granted dating back to some of the old records too. For instance, the patent office in the United States has searchable records since the 1970s. So you can go back till the 1970s for a free text search. Now, the things to note is that prior art search is important to determine whether the invention is entitled to a patent. So to know whether the invention is patentable, you need to do a prior art search. And the prior art search will tell you whether your invention is new, that is, it satisfies the requirement of novelty, which is a requirement for granting a patent. It will also tell you whether your invention involves an inventive step. That's the second requirement. It is also called the non-obviousness requirement.